What is intellectual property? Intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, and names and images used in commerce. The modern-day understanding of the words intellectual property stem from laws passed centuries ago. In 1624, the Statute of Monopolies, and in 1720, the British Statute of Anne are often referred to as the origins of copyright and patent laws. In the United States, intellectual property falls under a few basic categories: patents, copyrights, trademarks, and trade secrets. Using the most recent data, the United States Patent and Trademark Office places the total value of IP at $55 trillion. The governing body for the intellectual property is WIPO, the World Intellectual Property Organization. WIPO claims that along with an increased level of financial security, intellectual property laws affect economic rights and are based on general moral understanding. In other words, humans should want to protect their own ideas and creations, and the protection of these things is a moral issue. Intellectual property, when placed on the information spectrum, often begins with knowledge or wisdom. When this knowledge or wisdom is an original or unique idea, it deserves to be protected, which is the reason behind laws governing property of the mind. From an information perspective, IP has been changing drastically with the increase of internet traffic. Ideas are spread more quickly across the internet, and ideas can be stolen, recreated, and destroyed, all from behind a computer. Remember the Candy Crush Saga debacle? The makers of the game wanted to sue every game with the words Candy or Crush or Saga because they believed they had the sole rights to use them. This is a perfect example of some negative aspects to IP. As technology grows exponentially, the laws governing these systems follow slowly behind.
A copyright is a legal concept enacted by most governments that grants the creator of an original work exclusive rights to its use, distribution, usually for a limited time, with the intention of enabling the creator of intellectual wealth to receive compensation for their work and be able to financially support themselves. Now for the pros and cons of copywriting. Pros. Automatic copywriting protection, which allows all works to be protected automatically. Another pro is immediate action. If your company owns a copyright on any work that is registered with the US Copyright Office, it can seek court injunction immediately. A con is that it costs too much and the registration and fee is a very tedious process. Another con is that it's very ambiguous. There are many rules and regulations which are really open to interpretation. Another thing is that it can create monopolies. Therefore, a person who has the copyright can do anything with his work, which means that other people cannot do anything. The following picture of Obama is a recent copyright infringement which was brought to court in recent times.
A trademark is a word, phrase, or logo that identifies the source of goods or services. Trademark law protects a business commercial identity or brand by discouraging other businesses from adopting a name or logo that is confusingly similar to an existing trademark. The goal is to allow consumers to easily identify the producers of goods and services and avoid confusion. Sikh trademark trolls aim to profit MH17 disaster after shadowy Malaysian company applies for Australia license. Company in Kuala Lumpur applied to the Australia Trademark Office to have the term MH17 trademarked. Applied for the name on 18 July after 298 passengers were killed. Trademark would give them right to ask for payment for using the name. The purpose is to ensure no party takes advantage of the tragedy for their personal gains.
A patent is a property right granted by the government of the United States of America to an inventor, to exclude others from making, using, offering for sale, or selling the invention throughout the United States, or importing the invention into the United States for a limited time in exchange for a public disclosure of the invention when the patent is granted.
Patent trolls, sometimes referred to as patent assertion entities or non-practicing entities, are generally owners of patents who don't intend to make use of their patents and own them solely for the purpose of suing other companies who accidentally infringe on sometimes vague or questionable patents. Despite the fact that patent trolls lose 75% of lawsuits, most companies will rather pay them a settlement fee to avoid the high litigation fees that can reach the millions. In 2011 alone, over $29 billion has been paid in patent settlements. Though intellectual property rights were intended to protect content creators, it is a double-edged sword and has given rise to companies whose purpose is to exploit these laws. However, there is a current push to change legislation to once again protect the innovators. Thank you. We will now take any questions.